So I'm going to start recording now. But the bar and whether that's right for you, these are the 6 key things that I think are really important when considering whether or not it's the right profession for you. They were definitely the things I considered. The first one is intellectual ability. Now, what I mean by this is you don't need to be a double first class honours student from Cambridge. You don't need to have 12 A stars at A level, GCSE, and sort of 4 A stars at A level. I mean, it's great if you do, but what I'm trying to say here is that's not what I mean by intellectual ability. What I mean by that is you have the intellectual rigour and the stamina to actually complete the courses and deal with the amount of study and examinations that you have to go through to get through the bar. I'm by no means would never describe myself as like a super intellectual person. I had average grades at GCSE and A level. I went to the University of Southampton and read history before I went on to law. So I was never like a complete sort of A-star student. So you can definitely do it. You've just got to be driven and ready to face the intellectual sort of side of the profession. More importantly than that, I think communication comes into it. You need to be a really good communicator. And by that, I mean the ability to sort of adapt to different communication skills depending on the audience. So if you're talking 1 minute to the client in the holding cell, you could then be talking on a hearsay point of law to the judge. And that requires a different level of professionalism each time you liaise with them. Next minute, you might be in with the jury. So your communication skills will differ and you have to be able to adapt. With adapting comes working and coping under pressure. The bar is renowned for being quite a pressurized profession. You can receive papers sort of very last minute, sort of a couple of hours before the hearing or on the day of a trial perhaps, and it does mean that you need to be able to take that material, digest it quickly and adapt to what's been tasked to you because that person is relying on you. So definitely have a think about any times where you've worked under pressure and whether or not you've coped well. And all of these things sort of feed into one, which is that you do need to have a really good level of commitment to the profession. There's been lots of times where I've had to say to sort of friends and family, you know, I can't come to that drinks because instead I've got to go read civil litigation. And that's because I'm committed to the career and I really wanted to succeed. And it does require a lot of commitment and a lot of sacrifice at times. So that's definitely something to consider. And the last 2 are sort of more personality traits and points, but you do need to have sound judgment and you do need to uphold a good level of integrity and professionalism. So moving on to routes to practice, I'm not 100% sure if we've got all law students here, so I will just touch upon what you'll have to do if you're not a law student like I was. You will have to complete a law conversion course before you can do the bar practice course, and that consists of either doing a PGDL or an MA Law, which incorporates the PGDL into it, but you get a master's level qualification, and that will bring you up to speed with those who have just completed a 3-year LLB. At that point, the 3rd-year LLBers and the PGDLers can move on to the bar practice course. After the bar practice course, you've completed that, you will be called to the bar by your Inn of Court, which we're going to come back to. And then you will start a 1-year or 18-month pupillage, depending on what it is with that chambers. And then after you've completed pupillage, you will make an application to chambers for tenancy. And it's actually only at the point of completing pupillage and getting your practicing certificate that you are a registered barrister. At the point of being called to the bar, you remain unregistered, which means that you can't actually practice as a barrister in your country. So you will need to get pupillage at some point to be a practicing barrister in the United Kingdom. So what are the musts that you need to do before you start the BPC? We're going to do the musts first and then the mays. I use that term because throughout the rules that you learn for litigation, you are constantly faced with whether the court should must do something or may do something. So it's good to get used to thinking about your musts and mays now. What you need to do before you start the BPC is apply to a provider. You need to apply to a provider directly. You no longer need to apply through a centralized system, and you do that via their website. You then need to join an Inn of Court, which we'll come back to in a minute. And at present, you do need to pass the BCAT. So that is a £150 test, and you can book it through this period of time. You book it through Pearson VUE online, and just note that some courses do actually start before the BCAT close. You can resit it, but you must leave 28 days in between each sitting, and it is a pure critical thinking test. So that means it sort of tests your ability to deduce material like you would in litigation assessments. Obviously, they're not on litigation, it's on different things, but it's a multiple choice format again. Practice tests are available for it though, and it's quite simple to pass, so it's not something to worry about. The other thing I would stress is that you currently have to do this to get onto any BPC course, but it is under review by the Bar Standards Board, so do keep up to date with the changes that the Bar Standards Board are making, because by the time you go to apply, perhaps you want to apply in 2023, it may be a case that you don't need to do it anymore, but at present for 2022 intake you do need to pass the BCAT to get on the course. And more information can be found on the lawyer portal, or if you just Google BCAT assessment, it will come up. So they are the musts, they're the things you must do. Now we're going to look at the things you may want to do. First up is work experience, and that takes the form of minis, mooting and solicitor shadowing. Mini pupillages are really important to getting good sort of sources of information for your pupillage application. So if you can get minis prior to starting the bar course, I would definitely recommend it. Mooting, try and get a lot of moots done and get as much advocacy experience or debating, whatever it might be, with your university that you can, because again, that will put you in good stead for the BPC. And again, solicitor shadowing, you're probably thinking, why would I shadow a solicitor? I'm here for a bar talk. Well, I recommend you do this because again, it gives you more ammo to answer the question, why do you want to be a barrister and not a solicitor? And then if you've done those three things and you feel like having a go, you can actually have a go at pupillage before you start the BPC. You can have a go in your third year of LLB or your GDL year. So if you've done minis, mooting, solicitor shadowing, or you've done like a good amount of voluntary experience rather than a mini, then definitely have a go at pupillage. Alongside that, I would recommend before doing the BPC that you take a bit of a break, however you want to. It is a really intense course, especially if you do it. It's a intense course whether you do it part-time or full-time, but full-time obviously it's crammed into a shorter period. So definitely have a brain break or whatever form of break you want before you start. So I thought I've added this slide in because I think it's important that you know how to approach mini pupillage applications, because they can be really important and you can get them quite early on. I did my first mini pupillage while in my second year of history, so it is possible to get them with no legal background at all. How you apply is usually on Chambers websites under the join us or a pupillage section. There's usually another subsection that says mini pupillage, and that's the bit you want. Most chambers will want a CV, and that's got to be 2 pages max, no pictures, no colours, nothing, just black and white, Times New Roman, size 12 font, 2-page CV, and a 1-page covering letter, again no longer than 1 page, no colours, nothing, just very basic. In that, you need to ask yourself why you want to do a mini pupillage at that Chambers, and then tell them why. So is it the fact that you grew up in that area and it's a regional set that you would like to practice in or see yourself practicing in? Is it just the practice areas themselves? So do you want to be a criminal barrister or a land barrister specialising in land law, and perhaps they offer a real specialist area of that? And any personal reasons or contacts, have you got any of those as well that you can just add in? What should you include in your covering letter? Well, you want a brief introduction of who you are and where you're at in your study, but try to avoid reciting the whole of your CV. You know, that's what your CV is there for, and they will mark that and look at that. But you need to tell them as well why you want to be a barrister, and usually why you want to be a barrister in that area. Why you would like to do a mini with them, and why you think you'll be a good barrister. So any sort of experience you've had to date, whether that's mooting, minis, or voluntary work in their field. So you should hopefully be getting minis or making mini applications, but you also want to be thinking about making an application to the INS. Perhaps some of you already have, but if you haven't, these are the 4 that you have to choose from. So you've got middle, Lincoln's, inner, and Grays. Grays is the smallest of the INS, with Lincoln's being the biggest. You've then got inner just behind Lincoln's in size, and middle just floats in the middle. So I'm a Middle Templar. I received a Diploc scholarship for my bar practice course, which helped me fund it, because one of the things to note is that the BPC is unfunded, so you have to fund it yourself. The only way you can get funding for it is through the INS, through ULaw advocacy scholarships, or through doing the Bpc Llm, which is available for postgraduate loan. So that are the only ways you can get funding. More information on the INS is found on Chambers Student. If you just Google Chambers Student INS of Court, it will come up, and that gives you quite a good overview. But in essence, they're there to sort of help you with funding. They offer PGDL and MA law scholarships as well. So if you are doing a conversion course, definitely apply to them for one of those scholarships before the BPC. You can receive both. But more importantly, they obviously offer the bar practice course scholarships, and they can sort of be awarded up to sort of £25,000. So they're definitely worth applying for, even if you think, you know, you're going to doubt yourself and be like, oh, I don't think I'll get one. Definitely still apply for one, because you never know. And the deadlines for these are always the first Friday in November for the bar practice course, and the PGDL is actually the first Friday in May this year. So the one for the INS of Court scholarships this year has already gone, so you would be looking at 2023 if you haven't already put an application in for the BPC ones. But for the PGDL ones, if you're going on to a conversion course, you are still in time. Don't forget though that you will have to have references for this, so there will be 2 references usually required, one academic, one personal, or they will both be academic depending on the IN. So once you've joined the IN, and obviously you have to then move on for the BPC, once you're on the bar practice course, they still support you through your learning, through the 10 qualifying sessions that you have to do to be called to the bar. And these comprise of mooting competitions, lectures and talks, dinners, residential weekends, mentoring schemes for pupillage applications, marshalling, which is where you shadow a judge rather than a barrister, and obviously call night. Your call to the bar is done by your IN. So we're now going to move on to looking a bit more at the bar practice course itself, what it consists of, what you'll study. As you can see on the screen, there is 2 areas that you study. You study knowledge areas and core skills. Skills obviously testing your ability to be a barrister a bit more, and then the knowledge areas testing your knowledge on what you will need to know in order to practice as a barrister. Now, what I want to say is the course was changed last year, so don't listen to anything that's sort of said about the course prior to that, especially in terms of litigation and ethics. Civil litigation, evidence and resolution of disputes out of court, is now part open book and part closed book. So part 1 is closed book and part 2 is open book. And it now also includes alternative dispute resolution. So it used to be the case that you'd have to sit a separate examination for that, but the Bar Standards Board changed it. So you don't have to do that anymore. And then you've got criminal litigation as well, which is again the other big litigation paper, but that's remained the same. So that's still just one paper that you sit. What I would say is there's no sort of written assessments like there is undergraduate in examination conditions. So the litigation assessments are probably the biggest assessments you sit on the course, but they are multiple choice and single best answer only. So they're not written essays or anything like that, and they're set centrally by the BSB, so they're not marked by any of the providers and they're not written by the providers. Professional ethics, however, used to be written by the BSB, but it's now written by the institution. So the University of Law wrote my ethics exam and examined me on it and marked it. And again, it's now multiple choice, it's not a written exam anymore. Moving on to core skills, you've got your advocacy, which is 3 different assessments. So civil applications, which is where you write a skeleton argument, you submit it, and you make the oral application in support of your skeleton. Cross-examination and examination in chief in a criminal context. And drafting, which is where you draft a particulars of claim or a counterclaim in a civil or contract context again. And opinion writing, which again is civil or contract context, and you get given case papers and asked to write whether or not you think they have a claim, whether or not you think they have a defence to the claim, depending on what the solicitor's asking you to write, and you draft that through doing legal research and then submit it. Finally, you've got conference on here, which is again in a criminal context where you sit pretty much in a conference session. They tell you all about what they've been through, and you advise them on the basis of what they've told you, whether to plead guilty or not guilty, and whether they should have their case heard in the magistrates or the Crown Court. So that's what you study on the course. If you do this full time, you will study all of these at the same time and sit the assessments sort of fluidly throughout that one year. If you sit it part-time, you will do civil in 1 year. So you'll do all the modules relating to civil in the first year, and then all the modules relating to criminal in the second year, or vice versa, depending on how the university runs the course that year. So where can you study with ULaw? Well, these are the locations we currently offer the BPC at. The entry requirements is a 2-1 or above in a qualifying law degree, or a 2-2 we will also look at. So don't be afraid to apply if you are predicted or are in line to get a 2-2. We will still consider your application. I won't spend much longer on this because I'm aware this information is on the website. And then when thinking about ULaw, as you know, there are other institutions that offer the BPC, like that everyone knows that. But these are the reasons I chose ULaw. And basically they were the 4 that I sort of came to the conclusion when people always ask me, like, why did you choose ULaw? These are the 4 reasons that I ended up sort of figuring out was the reasons why. So I wanted to be a criminal barrister. I knew that coming onto the course, so advocacy sessions were always going to be really important to me. So I liked the fact that we were in line to get lots of contact, which we did. I had like sort of classes of four people in most of my advocacy sessions. So I got lots of contact time and feedback, and it was all taught by barristers and solicitor advocates. Alongside that, we had to go through a selection event, which meant you had to be selected to go on the course, which again, I liked because it meant that I was guaranteed smaller classes alongside selected students who were like-minded like me. My biggest class was my litigation class, and that was 14 people. We started with 16, but through to few dropouts and changes of careers and things like that, we dropped a few 2 or 3 students, so we were down to sort of 13 or 14 for the rest of the year. So it's a very small class. And I studied at London Bloomsbury, which was the biggest campus provider of the BPC. So if you go to other areas, you will also have probably even smaller classes. Alongside that, the selection event gives you an opportunity to apply for another scholarship, which you can receive as well as an in scholarship. It's part of an advocacy. You become part of the advocacy committee. So if you've done a lot of mooting, you've got a lot of mooting experience, then it's a good opportunity for you to get another scholarship through being an advocate. But I didn't actually get one. I didn't have a lot of mooting experience when I applied for the bar practice course, and I still benefited from the advocacy committee because they host lots and lots of internal mooting opportunities. So I was able to sort of do 4 or 5 competitions and boost my CV while on the bar practice course. And then finally, the careers team, I have a massive thanks to them for helping me get pupillage, because I'm severely dyslexic. So I felt I needed a lot of proofreading time, and I started my applications really early. And the benefit that I had from accepting my place with ULaw sort of quite a bit before September meant that I was able to access the ULaw employability team from the minute I had it accepted. So I was able to start drafting and getting feedback on my pupillage applications very early on, which definitely helped me in the long run. So if you do choose to make an application to ULaw, you will have to undergo the selection process, but I promise you it sounds more scary than it is. It's simply a selection event that's run virtually online now, and you do an advocacy exercise, which you're given 40 minutes to prepare or a bit extra time if you need it with a DSA agreement. You're given 5 minutes to deliver that to the tutor that's interviewing you, and it's that piece of advocacy that is considered for an advocacy scholarship. Once you've completed the advocacy exercise, you get interviewed with a member of the BPC staff who test you on a range of questions for motivation and analysis and like reasons for coming to the bar, that sort of thing. And then while you're in the waiting room, there's also advocacy scholars that are in there to talk to you about the course or answer any questions you may have about ULaw. So you kind of benefit from the selection process as well. And it's really not that scary. And we look to see raw talent and ability at the selection event. So as long as you're really keen, you're really up for giving it a go, I'm sure you'll be absolutely fine. So briefly looking at the study modes and the Bpc Llm now, we know we can do it part-time or full-time, but if you choose to do it full-time, that will be 2 days a week for definite, with 2-hour classes with an extra day on the days when you do advocacy. So it's 2 to 3 days a week. If you choose to add the LLM onto the course, it will be an additional 4 to 5 hours of study per week. And then our Bpc Llm is taught in 3 different pathways. So you've got the dissertation route, which is very standard of an LLM format. You write on a topic of interest and you get a supervisor. The optional module route, which is where you take 2 optional modules at the end of the bar practice course. So this is all done after you've done your BPC study, because ULaw appreciate that you're doing a lot already on the BPC, so you don't really want to add a huge amount more to that. So the optional modules only get taught after you complete your BPC, and the same with the dissertation. And then the pro bono experience is by far the most popular option, because you basically get an LLM for doing sort of voluntary work that bolsters your CV anyway. But pro bono does run a little bit alongside study, as in you may have a case where you have to do a meeting with a client for sort of 1 or 2 hours on a Wednesday, just because that's how pro bono runs. But you don't write your evaluative piece, the reflective journal that you have to do for the pro bono, until after the bar practice course again. So it definitely fits within the schedule. You will get a level 7 qualification out of it, and like I said before, if you are a UK or EU student, you can obtain postgraduate funding for it as well, and that's alongside an in scholarship and an advocacy scholarship if you're successful. So there is lots of routes for funding here. So now we're going to speak briefly about the pupillage process, as that's the last part of becoming a barrister. In essence, it's in 3 different phases. The first phase is the paper sift, which is where you write an application to chambers answering their set questions. That's marked, and then you if you're successful, you're invited to a first round interview. To give you some sort of fictitious numbers, paper sift, 400 applications go into chambers, around 60 are invited to a first round interview. First round interview, you will do 15 minutes, sort of 2 or 3 questions, maybe even 4, depending on how many chambers wants to ask. And usually it's to test your ability to answer questions that everyone's answering. So like a current affairs question, an ethics question, and they sort of put you up against, you know, the other candidates to see how you respond to those questions. If you're successful in that first round, you'll be invited back to a second round. This is sort of 60 people go down to 12 who are interviewed for the second round interview. And this is much more rigorous. It usually involves an activity of some sort, so a piece of advocacy or a case preparation, whatever it might be, depending on the area of law you're going into. You're also asked a lot more personal questions, sort of about who you are, your background, that sort of thing, off of your application. But really, chambers tend to switch the process up depending on, you know, their set and what they want to ask. It's a very different process when interviewing at different sets. So that is the standard process, however. And then offer day is now one set day in May. So it's the 6th of May. That means if you're interviewed in April for a second round, you won't hear back until offer day on May. These rules were changed last year to allow the candidate to be in the best position to make decisions on which pupillage they wanted to take if they were given more than one option. So that's why that's there. But it is also important to note that sometimes chambers tend to divert from this structure, and they may possibly do a secondary paper sift if they need to, or an assessed mini pupillage, or a third round interview, which is more common at the commercial or chancery end of the bar. So going into this, it's important also to note the figures and also divert from the figures, because it's important to know what these figures mean. So the Pupillage Gateway figures, this is how many applications were made on Gateway and how many pupillages were available on Gateway. What I mean by on Gateway, and I emphasize it, is that although there's 246 pupillages on Gateway, not every pupil is recruited through Gateway. So although all chambers have to advertise on the Pupillage Gateway, they don't all have to recruit through it. So this only accounts for those who were recruited through Gateway. For example, my set, that they didn't recruit through Gateway, they advertised on it, but I had to send a CV and covering letter into chambers, and they dealt with the application that way. So there's probably around another 210 pupillages out there that are off Gateway. So there's a sort of over that figure, but it's important to be aware of that. I know the figures look a bit scary and probably a bit off-putting, but to sort of put your mind at ease a little bit about this, at ULaw we have a really good employability rate. Over 52% of those from the 2018 to 2019 cohort either have a pupillage secured now or have already completed pupillage. That's over half of those graduating from the BPC with ULaw getting pupillage. So if you are thinking about going for pupillage and what you're going to be looking at to make those selections, well, I've listed the key things that you're going to look at here. It's going to be, again, geographical location, the practice areas. Are you really interested in one area of law? Tell them why. Any connections you've made through mini pupillages, the type of pupillage it is. So is it a 12-month or an 18-month pupillage? It doesn't mean much difference, but it might mean different to you. Pupillage Awards, so how much are they offering? At the end of the day, when you're selecting a chambers, you need to be able to live off of the money, because you are going to have to make money and pay rent if you move to London, for example. So it is important to consider that award. And sometimes the prestige of the set, is it a band 1 set for chancery law, or is it a band 4? That might come into it. It never did for me hugely, but for some people it does. So if you select a pupillage, you've been through the application process and you get it, you'll be looking at a pupillage year or 18 months, depending on which chambers, which is split into sort of the first 6, second and second 6. First 6 is spent non-practicing, so you'll be shadowing your pupil supervisor a bit like a sheep and just figuring out what to do. You'll also be getting extra advocacy sessions to teach you things that the bar course didn't have time to teach you, so because obviously every area of law is very different and they want to help you develop your advocacy. So you'll get extra advocacy sessions. You'll also be drafting a lot of documents and getting a lot of feedback on that as well. Your second 6 is when you're on your feet, so you'll be sort of driving with your L plates for the first time, is a good way to think of it. You'll still be supervised in doing that, but you will pretty much be instructed by solicitors yourself, running your own caseload and proving to chambers, you can do this job and they've taught you well so far. So second 6 is quite an exciting period, I hear, so definitely something to look forward to. And then your third 6 is either part of your pupillage naturally, because you do an extra 6 months because it's 18 months, which will be very similar to your second 6, or it will be at another set because you've made an application for tenancy in your second 6 and that has been rejected, and if that is rejected you will need to go to another set and do a further 6 months. If you make your application for tenancy after your second 6 and that's successful, you will in fact be a barrister at that point, and your name will be put on the door of chambers. So it's quite an exciting time, but I hear as well pupillage, which I'm sure you all know, is a lot of hard work again after the bar course. So definitely something to be clued up in. So that's all from me in terms of the talk, part 1 of this series anyway, which is just an overview of becoming a barrister. If you have any questions now, I'm going to stop the recording so that you can ask them, because sometimes it's nicer to ask in that environment. So I'm just going to stop that and I'm going to stop the recording.